What privacy rights do students have during virtual instruction? How should schools enforce school rules in the remote classroom? What happens when Big Brother thinks you'll shoot your eye out?
Yeah, this case involves a Red Ryder BB gun, folks. The very same from the movie A Christmas Story. So this case involves a BB gun, a 5th grade student who was not named Ralphie. And in today's episode, we're going to explore the intersection of privacy and technology with the case of Lancaster versus Board of Education of Baltimore County. This case highlights the previously uncharted waters of virtual learning. Courtney Lancaster, the mother of a 5th grader, faced an unexpected police search of her home after her son's teacher reported seeing what appeared to be weapons in the background during remote instruction. We'll discuss how this led to a lawsuit alleging violations of privacy and other constitutional rights. Stay tuned as we explore the implications of this case for students, parents, and educators navigating the fun terrain of remote learning. And it might make you want to rewatch A Christmas Story.
Always a good thing to do. Christmas in July, after all. Welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas. I've been a high school English teacher and a school attorney.
And I'm Jamie Cudlitz. I've been a middle school math teacher and principal. And now we're both professors of educational leadership, working to empower folks to better understand and navigate the laws that profoundly impact our schools.
This is the show that tells the fascinating stories connecting the courtroom to the classroom.
Chalk and Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
All right, Chris, you got a bell ringer for us today?
I do. And this is a topic that we've kind of talked about, not a lot, but it's definitely come up. So the state of Louisiana just passed a law that would require all public schools in the state to display the 10 Commandments in every classroom.
Really?
Starting in January.
No kidding.
Yeah, every single classroom, right?
Wow.
And so this is coming to us from an article by Libby Stanford for Ed Week. And Louisiana is not the only state who has kind of toyed with this, let's call it intersection of religion and public education. So we've had a ton of other states, and some of them we've talked about dealing with laws about, putting the national motto, "In God We Trust," in schools, kind of eroding that separation between church and state. But what's really interesting about this Louisiana law is it requires the 10 Commandments in every single classroom. The 10 Commandments have to be at least 11 by 17 inches. So you can't,
Really?
Yeah, you can't make them microscopic and pretend like you're following the law, right? So they're really prescriptive. And all of this is doubly fascinating because there was a 1980 Supreme Court case, U.S. Supreme Court case, Stone versus Graham, that said a Kentucky statute that required school officials to display the 10 Commandments in schools violated the First Amendment's Establishment Clause. So that case, admittedly is over 40 years old now. So this is kind of one of those areas where we thought it was settled, but now we've got this state kind of pushing the bounds a little bit.
And we've also got a new set of justices on the Supreme Court.
And the religious jurisprudence has moved a lot in 40 years. So, we've talked about Kennedy versus Bremerton. We've talked about religious charter schools before, which kind of Carson versus Macon kind of shepherded paved the way for those.
Yeah.
And so it's going to be interesting to see if that Stone versus Graham decision is still as strong as we thought it was. Because really what it comes down to is it's not like you can't talk about the 10 Commandments or anything like that. Like, absolutely, you can talk about those in schools. It's when you start kind of putting the 10 Commandments on a pedestal and kind of telling students that that is like the right way to live.
Yeah, this is what the state believes is.
Yeah. It's basically like when your intent is to promote Christianity,
right,
or, you know, your version of Christianity, that's where the problem comes. And the state, to their credit, maybe learned some lessons from Stone versus Graham, because this law doesn't just say you have to post the 10 Commandments in every classroom. It says that you have to post the 10 Commandments, but if you wanted to, you could also display the Mayflower Compact, the Declaration of Independence, and the Northwest Ordinance alongside the 10 Commandments, because these are all very important historical documents to the founding of our nation.
Oh, so they're basically saying this is not a religious thing. This is an important historical document.
Yes, and that is actually, you just quoted essentially what the bill says. The bill says, this is a statement from State Senator Jay Morris. The purpose of the bill is not solely religious. I think he probably should have left out the word solely there, because that implies it is partly religious, which is a problem. But he says that the 10 Commandments are simply one of many documents that display the history of our country and foundation of our legal system. And so, like, not only can you put these other documents up there along with the 10 Commandments, but you also have to include a context statement. And the context statement, it was added to the law after people said, hey, this might be unconstitutional. So the context statement, it's a 3-paragraph statement that explains the history of the 10 Commandments in American public education. And so the statement, it's written into the law and explains how the 10 Commandments has been used in education throughout American history, noting like how it's been used in textbooks and other things like that. So like, it's very much like hey, this isn't religious, we promise. This is just part of our national heritage, therefore it should be allowed in.
Wow.
And I still think there's this issue where like you're putting the 10 Commandments on a pedestal, and that still might run afoul of the Establishment Clause, but you can see how these lawmakers are kind of pushing the bounds of what may or may not be allowed.
Wow.
I know.
Okay, well, here it is again. It's rearing its head again, the 10 Commandments in schools.
Hydra laws, right? Like, we lopped off one head and now they're trying it again with a little bit different flavor.
Yeah. Well, I get, but that happens a lot, right? Like, you see how the courts reason when they make certain decisions. And so the losing party has an opportunity to go back and say, okay, if we decide to try this thing again, we know what things we need to address or work around or whatever, right?
Yep. We learned it. We haven't given up the objective, but we're going to try it again a little bit different.
Yeah. Wow. Great bell ringer. Thank you so much for that. And let's talk about today's case. Okay, so we've got Lancaster versus Baltimore County Board of Education. So what we're going to talk about here today is coming from the plaintiff's amended complaint. And basically what that means is that the court has accepted that all of the allegations there are true. Okay, so what we've got here, we've got student Doe. This is an elementary school student in the 5th grade at Seneca Elementary School. Okay, now, nice little side note here. He's also a Boy Scout.
And because he's student Doe, we don't actually know if his name is Ralphie or not.
Yes, it could be Ralphie. I'm going to go out on a limb and say I don't think it is. But
probably a good bet at this point, yeah.
Yeah, but student Doe does own a Red Ryder BB gun, amongst other weaponry.
As we will talk about.
Yeah. So he's been at this school for about 5 years. Mom's an active member of the PTA. She also served in the Navy with 4 years of active duty experience.
Okay.
All right. So that's a little bit of background here. So we're in the midst of the pandemic, and Seneca, like many of the other schools in this country, they turned to remote instruction. The complaint alleges that the board never really passed any policies related to remote instruction. They didn't ask for consent to video, when all the kids had their cameras on and things like that. They didn't ask for consent. They didn't ask for parental permission to view into student homes. They didn't restrict who could access Google Meet, which was the platform that they were using to do all of these remote instruction sessions. In fact, the only policy that the complaint alleges they had was that students had to have their cameras on at all times during class as part of the attendance policy. Now, I will say, none of this, looking back at it now, like, it sounds like, oh, wow, you didn't have any policies for this. But like at the time, there were tons of schools and tons of school districts that didn't have any policies for these things. They had never done it before, right?
Absolutely. Yeah, because like I said, they went to remote instruction. We went on spring break and we came back from spring break in the middle of the pandemic and we were no longer doing in-person learning. Everything was virtual.
Yeah, pretty much. Now, I mean, listen, not every school was on spring break when it happened, but that was right around the time. Like it was all over the course of pretty much 2 or 3 days, right? Like I remember the beginning of that week, I don't think there was really much on people's minds like there was on the Friday of that week, right?
Yeah. No, I was in an IEP meeting on Thursday and one of the attorneys who had been a nurse said, I don't think we'll be in school on Monday. And I remember thinking like, oh, that seems like an overreaction. Little did I know.
I was in North Carolina. Well, that's where I live on Thursday. And I was supposed to play a gig because I do some music stuff on the side. I was supposed to play a gig in Atlanta that Friday night. And I had my gear in my car on Thursday night. I remember talking to one of my buddies I was going to go play with on Friday going, I don't know if I should leave tomorrow or not, but I'm going to get everything in my car just in case. And then I remember getting up on Friday morning going, I don't know what's going on and I'd probably rather not be stuck in Atlanta if something happens.
Right. Yeah, no, absolutely.
So it's amazing how quickly that went. But anyway.
That is.
So, but like, yes, that's like schools were caught right in the middle of that, right?
So it makes sense that there aren't established policies at this point, right?
Yeah, exactly. All of this takes place over the course of about 6 minutes. Well, not 6 minutes. It's like an hour, basically, on June 1st, 2020. So,
are we going to do it like an episode of 24?
Oh, right.
10 a.m.
That might require more planning than we have the attention span to give this.
I also don't want to talk about this case for 24 hours.
No. Or hopefully not even 1 hour. But listen, so here's what we got. We got June 1st, 2020. So we're like a couple of months into this pandemic thing. Everything, for the most part, is remote. There's a remote learning session taking place on Google Meet, and student Doe is attending that session from mom's house. Now, unbeknownst to Doe, this is what the complaint says, that it was unbeknownst to Doe. His background is partially visible to his teacher. And in that background, what we have is a pegboard on the wall that contains 2 archery bows, 2 bundled sets of arrows, a Red Ryder BB gun, and an airsoft gun. And I think there were some other Nerf guns and things like that. And the airsoft gun has what most airsoft guns have on it that I learned for this episode, which is an orange muzzle, because that's apparently required by law for airsoft guns to have this sort of orange muzzle on it.
Yeah, and I'm looking at a picture of it that I found through a local news program, and like, this is a serious collection of, I hesitate to call them weapons, but like, it's pretty serious. It's very well organized. I will give the student a ton of credit for that. And it looks like, everything's well maintained too.
Did you say you hesitate to call them weapons?
Well, because like, I mean, that's going to be the whole shtick, or the whole issue here is like, are they weapons? Are they toys? We don't know. I just don't want to give away the punchline. But looking at this image, like I can see, the airsoft gun you mentioned has that orange cap, and like, it clearly looks like not a toy, but it looks like an airsoft gun. But there's 2 other gun looking objects that look a lot like weapons. Like one of them looks like a small caliber rifle. And then there's another one that is kind of disguised behind the airsoft gun that looks pretty legit. Like it's hard to tell from this based on like the shape, the coloring, like, it's all muted blacks and wood tones. Like,
yeah, but it's
I can't tell if it's a toy or not.
No, it's like 3 feet long, and pretty much anything that's on this pegboard, if you if you stepped foot on school property with any of these things,
Big problem.
it's potentially game over.
Oh, yeah.
Right?
Like any of these things, even the Nerf gun with zero tolerance policies would be a problem.
Right.
But like,
Right.
that's a different episode.
Right.
But like,
Yeah.
if you took the bow and arrows, if you took even the airsoft gun or one of the other ones that looks pretty gun-like, that you're looking at a 1-year expulsion probably,
Yeah,
at least.
exactly. Okay. So what happened was at 10:56 a.m., the teacher notices the BB gun and the airsoft gun. The BB gun that the teacher is referring to here is that big gun that you were describing, that
Right.
3-foot long thing.
Looks like a small caliber rifle, could be a BB gun, but there's nothing from this distance that indicates it's a toy.
Yeah. And this pegboard, folks, is like floor to ceiling. Like
It's legit.
Yeah. So the teacher notices the gun, the two guns, and asks that Doe change his background. And Doe does. What did Doe do? Doe did that. Sorry. At no point, though, did Doe mention the toys. At no point did Doe handle the toys. At no point did Doe threaten anybody with them. They were just there in the background.
And the teacher asked to change the background. He did.
And game over, right? Have a good day. Thanks for listening.
That I was going to say, that does seem like that could be the end of the episode.
But it's not.
It never is.
Apparently, somebody took a screenshot before Doe changed his background. Somebody took a screenshot. And again, like we said, there was no restrictions on who could attend these Google Meets. So we don't know. Maybe it was another parent who had logged on. We don't know, but a screenshot was taken. The teacher reported Doe to the school administration, and the school administration gave that screenshot. So we're not sure how the teacher got the screenshot. Either the teacher took the screenshot or was sent the screenshot from somebody else. But the teacher sent that to the administration. The administration gave the screenshot to the school's assigned safety manager. Okay, so like the SRO. All right. All of this takes place within a 30-minute window.
Wow.
Yeah, it's quick, man. Things move fast on the internet.
Especially for the number of people who had to handle that, right? Like it sounds like it went from like the person who took it to the teacher, to the administrator, to the SRO. So yeah, it went through like 4 or 5 people in less than half an hour.
Yeah.
That's quick.
That's quick. That's
especially in schools.
Right. So within that 30 minutes, the vice principal called Doe's father and asks where Doe was.
Right. So within 30 minutes of the screenshot, somebody's already calling Doe's parent.
Dad. Yeah.
Okay.
And saying, hey, where's your kid? Now, the interesting thing here is that the vice principal lies to Dad about the reason for the call. They tell Dad that it's because Doe is having internet connectivity issues, which I'm sorry, but it reminds me of that scene from Parks and Rec. I don't know. If anybody watches that show, you probably know what I'm talking about. But anyway, we won't go into it. But the VP tells Dad that Doe was having internet connectivity issues, so they wanted to know where he was. All right. So the dad tells the administrator that Doe is at his mom's house. Mom never received a call.
I guess, what is the vice principal doing calling Dad? Like, what is it that they're trying to accomplish?
Well, given the speed with which the school then contacts police, which is the next thing that happens here.
Yeah.
I'm going to guess that the vice principal just wanted to know where the kid was so that they could pass that information along to the police. And again, I'm guessing that the reason for the lying was to not tip them off.
Sure. Okay.
Right?
Okay. So I guess there's a concern here then with student safety or, and I think like having like, if you're a minor, you're not allowed to have a firearm or something like that in this jurisdiction. So like, but I don't think like the school isn't trying to enforce the criminal law here. That would be a whole different issue.
Well, Yeah, again, it's, given the information that we have on this, it's hard to get into the school's head, what they were thinking. Did they think that a criminal act had taken place or was taking place? Did they consider it to be sort of a violation of school rules to have weaponry
visible on the camera?
Visible, even though there were no policies like that. Maybe they were just kind of thinking, well, it's school time.
Right.
And because weapons aren't allowed in school, they shouldn't be allowed to be visible on your camera.
Right.
Who knows what they were thinking?
You don't call the cops to enforce school rules, though, right? And school administrators typically should not be in the business of investigating
criminal
situations
yeah.
that they think are violations of the criminal law rather than violations of school policy. So there's this, I guess I'm trying to figure out what was the VP trying to accomplish here? And
what did they see as their role?
Exactly. Yeah. What was their goal? So the most, I think, understanding or perhaps generous interpretation of what the VP is doing here, calling dad, is they want to do a wellness check on the student.
Okay. Let's go with that for now. You want to know what happens after that? Because it gets crazier.
Always.
Okay. So after the call to dad, the principal calls the Baltimore County Police Department and tells them that, quote, a shotgun or rifle was seen in student Doe's Zoom background. Okay. The principal tells the police department that, yeah, we acknowledge that this isn't on our school property, but the student still must follow the rules as if they were at school. So given that, it almost sounds like the principal was saying
it's a school rule enforcement issue, right?
Yeah.
But that's not you don't call the cops to enforce school rules.
Exactly. That's where they're saying this is a school rule violation, but police, you've got to handle it.
Right. Putting this into context again, this is a few months into the pandemic, right? So nobody knows how to handle any of this stuff because it's all brand new.
Right.
And we're all just kind of making it up on the fly. So I guess the lines of authority and maybe, an issue of resources too, right? How's the school doesn't have people to go knock on people's doors.
And the interesting thing is the principal saying this is a violation of school rules and getting the police to come in and deal with that. If this took place in a school building, yes, you would call the police, but you're doing that to mitigate a potential imminent threat, right?
Right.
Which in this case, that would be a difficult thing to prove that there was some sort of imminent threat.
Right. Because it's just on the wall behind this student.
And it's all virtual. Nobody's in the same place.
Mm-hmm.
Anyway, so the principal tells the police that the gun did not have a Nerf gun look to it. So they weren't looking at the Nerf gun. They were probably looking at the airsoft gun and the BB gun, the Red Ryder. You'll shoot your eye out. So then the principal says, it looks like there's a pattern coming here. Then the principal tells the police that the student purposefully ducked to give everyone a better view of the weapons. Now, just remember what we said a few minutes ago, that there was zero calling attention to of these weapons.
So that's really interesting because the idea that Doe didn't mention the toys, handle the toys, or threaten anyone with the toys doesn't foreclose the possibility that he moved to give people a better look at the toys.
Yeah.
So those statements are not necessarily inconsistent, but I think.
But we're in some gray territory.
And I don't know if it really matters.
No.
It might matter for punishment or something like that, but having the gun visible and moving so that the gun is visible, I guess that shows a little bit more intent rather than just oh, I forgot it was there.
Mm-hmm.
But that seems such an insignificant detail.
Yeah.
Potentially.
Yeah. So why throw it in? Right. So at this point, it's 11:49. And keep in mind, this all started at 10:56. So this hasn't even been an hour.
We've been talking about it about as long as it's taken.
As it's taken place, right? So at this point, less than an hour after the teacher noticed the BB gun, there's a knock on Mom's door. And guess who it is? It's the police.
Uh-huh.
And not Sting and Stuart Copeland.
That would have been a different...
So the police are knocking on the door, and the officer tells Mom that there's reports that her son has a weapon in the house, and he asks for permission to come in. So now we've got some body camera footage that's here to help us know what's going on. So the body camera footage shows both the officer and the mom being surprised that the officer was called into the home in the first place. So mom tells the officer that her son does have toy guns and allows him to go upstairs and take a look.
Okay. So mom says, yeah, that's weird that you're here, but like, come on in, you can take a look.
Yeah, I got nothing to hide. Okay. So the officer goes up to Doe's room and immediately identifies the BB gun and airsoft gun as toys. Like, so the officer knew what he was doing, knew what he was looking at, and he said, okay, those are toys. Also noted that the toys were not loaded. The projectiles for those toys were securely stored in some other location in the house. And the officer expressed his satisfaction that the mom and the son were aware of firearm safety and that the toys were safely stored. So basically, the officer comes in, looks around and says, it's all by the book here.
Yeah. And looking at the picture, that does not surprise me because someone seriously takes care of that stuff just by looking at how organized it is.
Exactly. So the officer comforts Doe, who was obviously frightened.
Scared out of his mind.
Here I am.
A fifth grader,
doing my class stuff in my bedroom. And the next thing I know, there's a police officer in my room, looking at my guns. So the officer comforted him and apologized for bothering them and leaves. Shortly thereafter, another officer arrives on the scene, but it says that they deferred to the first officer's assessment. It doesn't seem like the second officer even went inside. And you would think everything is said and done, right?
Mm-hmm.
So now it's lunchtime. It's about 12:20.
Okay.
Mom calls Doe's homeroom teacher, who said that it was a parent who was on the call that noticed the guns, that told the teacher, and then the teacher reported the guns to the school administration.
Okay.
So whether the teacher noticed the guns beforehand and didn't think anything of it or didn't think that it was a problem or whatever, once another parent informed the teacher, then the teacher just went ahead and informed the administration.
Yeah.
Okay. So a few minutes after that, mom calls the administration, talks to the vice principal and the principal.
So within 2 hours, all of this stuff has happened and mom is already on the phone with the VP and the principal.
Yeah.
Like, I love that. Like, mom is really proactive and involved, it seems.
Well, I mean, honestly, like the police just left her house.
Yeah.
I'm not surprised that she's like, okay, I got to talk to somebody about what happened here.
Hey, what happened? Why did that happen?
So mom's on the phone with the VP and the principal, and they explain that it was the school safety officer who made the determination that the toys were not toys, they were weapons.
Which, looking at the picture, seems totally reasonable.
Not going to argue that. They failed to mention that they called dad, and they failed to mention that Doe allegedly purposefully ducked to provide a better view of the toys. So they omitted a few interesting pieces of information there.
But if you're the administrator, you're not going to tell mom that like 2 hours after it all went down.
No, I mean, it's kind of, I find it kind of interesting that they didn't mention that they called dad. Like I'm thinking as an administrator, why would I not tell them something that they can easily find out on their own kind of thing?
But you're not going to say like, I called dad and lied to him.
Right.
Right.
So there's something a little, it seems like there's some shady stuff going on here.
Yeah, something weird is
not the full truth, the whole truth, and nothing but the truth.
Right. not as much transparency as we would hope.
Exactly. So the next day, mom emails the executive director of school support for the elementary school and the superintendent. So this sounds like it's a district position. The executive director has a conference call with mom and dad and acknowledges that the screenshots are the only evidence that they have and that mom and dad will receive a copy of the screenshots.
Okay. So now we're like, not only are we talking to school level administration, now we're at district level administration within like 24 hours. So, I think we said at the beginning that mom was a member of the PTA. That does not surprise me that she knows how to work the system like this.
Yeah, exactly. Like she's gonna go through the channels. So the following day on June 3rd, mom speaks directly to the school safety officer who identified the toys as weapons. And the SRO relayed that she had firearms training from the Baltimore County Police, but did not state how she identified the toys as guns. She basically just said, look, I've been trained by the police. I was the one who identified those as weapons. Didn't go into any other detail. She said to mom and dad that the photographs would be released to them, although she refused to turn them over herself. She said, I'm not going to give them to you, but you'll get them.
Right. Yeah, that's got to go through the proper channels.
Right. Now, if you don't think things were wild enough.
And wait, there's more.
But wait, there's more. There's always more. Between June 12th and June 13th, a news station, the local Fox news station, ran a follow-up story about the incident. A number of times they ran this story. And in that reporting, they had an officer, not the one who came out to the house. They had some different officer talking to the news station or giving a report to the news station about what happened, but it was not a correct report.
Okay.
It was either false or incomplete.
Okay. What did the officer say?
The officer said that the police report indicated a suspicious condition, that the principal received an email from the teacher about a child playing with a toy gun during virtual class. The teacher told the child that he would be removed from class if he would not stop playing with it.
Okay.
Now, we know this was a false report because no official police report of the incident was ever done.
That's a problem.
Yeah. So there was no official report, but there was an officer providing facts as though they came from a report. Okay.
Gotcha. Well, and if that were if that statement of what had happened had been accurate, I think that would explain the school's reaction a lot better, right? Like there's there's a child manipulating a gun. We can't tell if it's a real gun or not. Somebody needs to go check on this kiddo.
Right.
Like, oh, okay. Now, like if that's what actually happened, I think that explains a lot more of what the principals did here. But like, we've got these other side of the story, which is saying like all of this is wrong.
But that's, we talk about that a lot, right? Like the law is very, very fact specific. So you change one little thing and it could change the whole case.
Right.
So one of the ways that they knew that this was a false report was that the police officer who gave the report kept referring to the principal as a she, but the principal was male.
Okay. Yeah.
So, okay, maybe that could be an honest mistake. I don't know. But anyway, the point is there was a lot of other made up stuff.
Okay.
It also was not an email that went from the teacher to the principal. It was a verbal report. And no one ever accused student Doe of playing with a toy gun. Anyway, so all that's, a big old nothing burger, right?
If it is untrue, you don't want the police to go on live TV and talk about untrue allegations.
Exactly. Anyway, that's all part of the story here. So then mom sends a public records request to the school and the police. And then after the school resource officer and the district person both committed to providing the evidence to the parents, the school denies the public records request for the evidence.
Okay. So this is where like that conversation you and I were just having about like something odd seems to be going on here. Like this feels weird.
Feels like they're hiding stuff.
It kind of feels like they circled the wagons, right?
But it almost feels like they were hiding stuff right from the beginning of this, right? Like they weren't being completely forthcoming with what their goals were, what their intention was, why they were doing what they were doing. And now it seems like it's,
about to come back to bite them.
Yeah, exactly. Like you keep holding on to a lie and it gets bigger and bigger, right? Until you can't maintain it anymore.
Right.
So anyway, as a result of all of this, mom and the student claim that they still experience emotional and psychological effects of what they refer to as being betrayed by the school system, the infringement on their privacy and their constitutional rights. They claim that they had reputational harm and harm in their standing in the community due to personal humiliation. I'm sure that this was the talk of the town.
Right.
Right? Like this was on the news.
Yeah,
right?
Especially if the news report is inaccurate, right?
Exactly. So they decide to file a lawsuit.
As they usually do if we're talking about it.
That's right.
Yeah. So a few months later in November of 2020, mom and student Doe bring a lawsuit in state court alleging 16 different claims
Ooh,
against
boy.
both the school district and the county and the police department. So
Bring it.
we've got a lot of allegations. This is a pretty big laundry list. So they're alleging violations of Maryland's Wiretapping and Electronic Surveillance Act,
Ooh.
violations of Maryland's Camera Surveillance Act, a
Wow.
whole bunch of tort claims. So negligence, negligent training and supervision, 3 different flavors of invasion of privacy, defamation, negligence, breach of fiduciary duty. It's all in this list. There's a ton of claims here. And they also allege some constitutional claims here. So we've got a number of constitutional claims under both the Maryland and the United States Constitution. So there's allegations of violations of the Second Amendment and the right to bear arms, the Fourth Amendment's right to be free from unreasonable searches and seizures, and then the Fifth and 14th Amendment, which both deal with due process. So
Okay.
a lot of claims here.
Great.
And then the cherry on top,
Oh, there's more.
there's also an allegation of a violation of Maryland's public records laws.
Oh, because they didn't get the evidence that they asked for. Wow. Good
So
times.
a lot to unpack here. So
Okay.
mom files this complaint with the laundry list of allegations, but because there are federal claims here based on the U.S. Constitution, the defendants get the case removed from state court into federal court. So we're now in the federal district court for the District of Maryland because of these federal claims.
Does that mean they're not going to address all of those other allegations that are state things? Is that what happens?
So if it gets removed and it has federal claims, the federal court will still decide the other claims if they all kind of arise out of the same set of circumstances.
Okay.
So the federal court could still decide the state claims, assuming that there's always a federal claim to kind of get you in the door,
Okay. Got it.
which good previewing because there might not be federal claims for much longer.
All right.
So we get into federal court and immediately the school defendants file a motion for judgment on the pleadings, and the county files a motion to dismiss for failure to state a claim upon which relief can be granted. So this is one of our favorite legal vocabulary terms. This is a 12B6 motion.
12B6. There it is.
Yep.
Yeah.
So the court is looking at this, and so that basically means all we've got is the complaint. We haven't gone through the pleadings. We haven't done discovery, nothing like that. So we don't have a lot of evidence to go on. And so the school and the county are essentially saying, take everything that mom said is true, and that still doesn't prove we violated the law.
Okay.
Even if you draw all the inferences in her favor, that doesn't give rise to a plausible claim that we broke the law.
Okay.
And, this is a fairly low bar. So like all mom has to do here is state a plausible claim that she's entitled to relief. But that can be tricky, especially if you don't have all the information.
Okay.
So the federal court is looking at the federal claims. So we're looking at these constitutional claims. Let's start with the Fourth Amendment. We're going to do them a little bit out of order.
Okay. So the Fourth Amendment, just as a reminder, is the right for people to be secure in their persons, houses, papers, effects. It's the thing that protects us against unreasonable searches and seizures, right?
Exactly.
Okay.
Right. And so mom is alleging that the school unreasonably searched Doe's private residence without consent, and that it's hard to imagine a more intrusive thing than having a camera on in your house by the state during the entire school day. So mom is basically saying this is a massive invasion of our privacy.
So they're referring to the school searching through the camera. They're not talking about the police officer coming in.
Right. Well, no, because they couldn't do that because they consented to that search.
Yes.
And so if you consent to the search, then
exactly.
the Fourth Amendment, you
Okay.
kind of waive
So
your rights.
what we're talking about here is the teacher looking or the parent looking and saying,
there's a gun in the background.
there's a gun in the background, and
Right.
that's the search.
Yeah. And
Interesting.
there's something to this where that is a pretty, having a camera on in your house that is broadcasting to the state 24/7, that does feel very Big Brother, right? Like,
well, I don't know if it's broadcasting 24/7, but
I hope not, right? Like,
but like it's on,
mm-hmm.
and while it's on, while you're in school, you technically are broadcasting to the state.
Right.
But Chris, you know about it, right? Like how can you be unaware that you were being viewed?
And I think that's a really good point. Like, you chose to turn the camera on, right? And Doe could also control the background too, right?
Yeah.
So like you can control what the state sees. And I think that's a huge fact that, the court doesn't really grapple with. But to me, that's kind of a crucial thing where like
he could sort of choose to put the camera on because remember there was that policy, right?
That you had to have your camera on for attendance. Yeah. But if you can control the background, you can control what they see.
Yes.
And then if you can mute your mic, like maybe you can control what they hear too.
Yes.
So like it's not as intrusive as they're making it out, right? Like,
yes, that makes sense. Okay.
So but like if you accept Mom's argument here, like that would make all remote learning a potential constitutional violation.
Yeah.
Because by necessity, remote learning, you've got to do it from somewhere.
Yes.
Right? Like, so the court looks at this and as a baseline to establish a Fourth Amendment violation, you have to demonstrate that there's been a search. And a search means that the government intruded upon a reasonable expectation of privacy, meaning you thought the thing was private and it's reasonable, meaning society is willing to recognize it as something that should be private. And the court looks at this and says, you know what? It's kind of like unreasonable to expect that your home or like that remote learning wouldn't happen, right? Like it's one, like you didn't expect to be private. So there's this lack of a subjective expectation of privacy.
Yeah.
And then two, like society probably isn't willing to accept the idea that you have an expectation of privacy in remote learning, because if we accepted that idea, then remote learning is gone.
Yes, exactly.
So the court kind of comes back and says like, there's no search here.
Right. And even if there was, they turned their camera on, right?
And you chose to. So like you essentially consented to it, right?
Yeah, exactly.
But I think that like the compulsory attendance thing, I think undercuts that a little bit where like,
you've got
we told you had to go to school and then we told you when you're there, you had to have your camera on.
Well, and that's one of the reasons why I mentioned that is like, is sort of a way to provide schools and administrators who are listening with like, okay, you might want to if you've got a mandatory turn your camera on policy, you might want to rethink that, I'm not saying you might not want to have it. I'm just saying you might want to think about how you do that.
Right. How you implement it, what recommendations you give to students, like, hey, have a virtual background or choose a neutral background in your house, or, to the extent you can. Right.
Yeah.
So like,
or mute, but it's mute when you're not talking or,
which you should do anyway.
Yeah.
Yeah. And so, on the search issue, like the court just ultimately concludes that there's no reasonable expectation of privacy when you turn on your camera for virtual learning.
Okay.
In today's digital era, to quote the court, and particularly in light of the crisis created by the COVID-19 pandemic, online communication and remote audio and video platforms are commonplace and indeed necessary.
That all makes sense. So basically, Mom, invasion of privacy, unreasonable search, you don't have a leg to stand on there.
Yep. And so the court grants the dismissal of the Fourth Amendment claims. So Fourth Amendment claims, school wins.
Okay. So what about the 14th Amendment?
So the 14th Amendment. So they're arguing here a substantive due process claim.
That's a tough one, right? Like
I know, because I can't say substantive.
It's a tough one for two reasons. Because we've got substantive due process and we've got procedural due process, right?
So procedural is basically, did they follow the steps that they need to follow in order to deprive you of life, liberty, and happiness? Or property, not happiness. That's a different document. Substantive due process is basically asking, did the government have sufficient justification to do what it did? And, it's ensuring that governmental action is not arbitrary.
So in this case, it's basically asking, did the school have justification to what? To call the police? Did the school have justification to do what?
Yeah. So Mom is basically arguing that the school's behavior shocks the conscience and was kind of, didn't have substantive justifications because the school didn't have justifications to lie to dad. The school didn't have justifications to call the cops. The school didn't have justifications to
bring all this
up. And then, And then, on the police side, like the police didn't have justification to come to the house, and they certainly didn't have justification to lie to the press.
Yeah.
Right. So like all of those things are kind of wrapped up in this substantive due process complaint.
Interesting.
Or claim. And in order to establish this, I think I already said this, but you have to like allege conduct that shocks the conscience, because this is a constitutional claim, and we're not just going to constitutionalize like run-of-the-mill negligence or things like that. Like there's other legal remedies for that stuff. So this is a really kind of fairly high bar. And the court looks at this and says, none of this stuff really is conscience shocking in the constitutional sense, because like the school reasonably...
Like that's a big gun.
Right. Yeah. Like they saw something that they could reasonably conclude was a weapon. They took a screenshot. They reported it up the chain of command. They notified the police because it was reasonably determined to be a weapon. The police check determined that nothing was wrong. Like the worst thing that mom alleges happened is that the school lied to dad about the reason for the call.
Yeah.
And they made misrepresentations to the police saying like, hey, it was against the rules and he ducked to show the gun and that sort of stuff.
Okay.
And, the court says like, yeah, like that might not be great, but like, it's also not egregious. Like they could have very easily had a reasonable explanation for that.
Okay. That makes sense.
And so because of that, like this isn't a 14th Amendment violation either.
All right, Mom, not doing so well so far.
0 for 2. So let's talk about the amendment that we never get to talk about in school law, the Second Amendment.
Hey.
This one doesn't come up a lot in education law.
No.
Not upset about.
No.
So
we have enough to deal with.
Right. So the Second Amendment protects the right to bear arms.
Can I stop you for a second there?
Yeah.
How did the school violate their right to bear? Like, I can't even...
You and the court both.
Well, you know what? And honestly, like, even if I hadn't read through this ahead of time, I do my homework, folks. But like, still, like, you're probably listening to this and wondering that exact same thing. How did the school violate their right to own a firearm?
Right. And that's a pretty attenuated argument that mom is trying to make here, where basically like, under the circumstances, like this whole governmental action that's going on is like basically discouraging her from owning a gun herself. Because like no one's arguing that the student has a Second Amendment or that the child has a Second Amendment right. Because like, we don't typically think of minors as having Second Amendment rights.
Okay.
And the court also says that you don't have a Second Amendment right to own a toy that looks like a gun. Like that's not covered by the Second Amendment either.
Second Amendment. Yeah.
Which is funny because are these toys or are they reasonably believed to be weapons? Because
according to the school resource officer, they're reasonably believed to be weapons, right?
Right. Yeah. So, I guess it seems disingenuous now to call them toys. But you're right. Like, there is no constitutional harm here. And that's kind of what the court says is like, hey, no one took away your right to own a weapon.
Yeah.
And the causal inference that you're trying to draw seems really attenuated, right? Like, you can still have a gun.
Yeah.
No one said you couldn't.
Yeah.
It's just, you can't give your kid one on a Zoom call. That's kind of all we said.
Yeah. They're basically saying, yeah, Mom, that's a stretch.
Yeah.
Okay.
And so
all right, 0 for 3, Mom.
0 for 3. And here's the kicker. Not only are you 0 for 3, you're 0 for 3 twice, because even if they were constitutional violations, the school officials would get
qualified immunity.
Qualified immunity.
Yay.
There's always qualified immunity. Right. So qualified immunity basically just asks whether or not there was a violation of a clearly established right. Here, none of the rights, like even if there had been a violation, the court kind of looks at this and said like, none of these rights were clearly established. Like this is all brand new to us.
COVID, remote learning.
Yeah. So like these school officials were kind of, they were acting reasonable. They were doing the best they could.
Yeah.
There's nothing here that would indicate that a reasonable school official would know that what they were doing was unconstitutional.
Yeah. Now that argument is not going to continue to hold up.
Right.
Now that we've had a lot of these kinds of privacy kinds of cases since remote learning started. So school officials don't think that qualified immunity is on situations like this is indefinite.
Right. You can't stick your head in the sand and claim qualified immunity.
Yeah. Yeah, exactly.
Because would a reasonable school official know about this stuff? That's the standard. So as more case law comes out, then it becomes more well established, the parameters of constitutional rights.
So the mom goes through all of this against the school, but she also goes through all of this against the county and the police officers, right?
Right. And it's the same story with the county and the police officers. The court dismisses all of those claims for pretty much the same reasons as well. So there was also Second Amendment, Fourth Amendment, 14th Amendment claims. Same thing with the Fourth Amendment. There's no intrusion into privacy really here. 14th Amendment is the same story. There's this issue about like the false police report. And the court kind of looks at that and says, hey, you know what? We're not saying that this conduct wasn't negligent. We're just saying it's not conscious shocking for the purposes of the 14th Amendment. And I think that's really interesting.
That is interesting.
If you've got this, that like, I have a very, very finely developed sense of justice, which probably surprises no one. So like, I want justice to be done. And so like this idea that like, no one violated anybody's rights, that might rub you the wrong way. But like the court is just looking at the constitutional claims. So there's still state claims that the court is just not touching right now.
Right.
And then, Second Amendment, same thing. No one really infringed on your right to own or to bear arms. So like, that's not really a claim that you can succeed on there either. And of course, they would all get qualified immunity anyway too. Yeah. So.
Oh, okay. So everything. So Mom's done.
Yeah. Mom, well, not done.
She's not happy.
So the court dismisses all of the federal constitutional claims. And then, Jamie, to your point earlier, like she still has all of her
the state claims, the torts and everything.
But now there's no reason to be in federal court. So the state or the federal court kicks the case back down to the state court to deal with the remaining state claims.
Got it.
And Mom and Dad appeal this ruling to the Fourth Circuit, but in what can only be described as one of the shortest opinions I've ever seen, in a one-paragraph opinion, the Fourth Circuit just says, what they said. And they affirm the lower court's decision. So Mom still has these claims in state court, and I wasn't able to kind of figure out what happened to them ultimately.
They wrote it at 4:00 on a Friday. They're like, I got to get out of here, man. What they said.
Right. And so, that's the story.
Wow. That's cool. It's an interesting case, man. That's, I mean, we don't see these very often, these remote learning ones, but like this was such a big part of reality for a while there for all of us.
Mm-hmm. And we're all trying to figure out what it means as we're building the plane as we're flying it with all of this. So like, it's really novel.
It's similar to the, what we talked about on the bell ringer for the last episode, right? Where we talked about AI, right? And how this is sort of 100%. Novel terrain.
Yeah.
Right. And we got to figure this stuff out. Well, that's this is also a similar situation, right?
Yeah. And I think now, a couple years later, like we've pretty much figured it out, right? Like I feel like we've got a good grasp on these issues now.
Well, whenever you're sort of thrown into the fire, you figure a lot of stuff out real fast, right?
Mm-hmm. You never know how tall you are until you're in over your head.
Oh, I like that.
You like that?
Nice.
I didn't come up with it, but
that's a good takeaway, folks. You never know how tall you are until you're in over your head. And if you're a school administrator, you will probably, on occasion, be in over your head.
You're going to realize that you are really, really tall.
Yes. But that's okay, because there are a lot of amazing supports and resources for you out there in addition to this podcast. Tons of great things, great support networks. But it's not an easy job, but the rewards can be pretty amazing. All right. Well, anything else, Chris?
Yeah. So your homework, drink your Ovaltine. And then find Chalk and Gavel wherever you get your podcasts. Like, rate, review, subscribe, tell a friend, share the show. We'd love to hear from you. You can find us on social media, or you can hit us up on our website at Chalk and Gavel, or chalkandgavel.com.
That's great. Do they still make Ovaltine?
I have no idea.
Okay. Well,
it's basically just like chocolate powder, right?
I think so.
I don't know if I ever had Ovaltine.
I never drank it.
I know Hershey's. Or no, what's the Bisquick? Not Bisquick.
That's a pancake
Nesquik. Yeah.
Okay. Well, all right. That obviously.
I think we're showing our
done,
ages.
Okay. Thanks for joining us. We look forward to diving into another case in a couple of weeks where we connect the courtroom to the classroom. See you then.